SJC-13697, Susan Miele versus Foundation Medicine, Inc.
Mertnight.
Yes, thank you. Good morning. May it please the court. Don Mertnight of Seyfarth Shaw on behalf of the appellant, Foundation Medicine. The Massachusetts Non-Competition Agreement Act was never intended to, and in fact does not apply to employee non-solicitation provisions such as the one at issue in this case. As the name of the act makes clear, the statute was intended to regulate non-competes, and the plain text of the statute provides that other restrictive covenants, including employee non-solicits such as the one at issue in this case, are not subject to the Act's requirements. Now, to be clear, that does not mean that covenants that are not subject to the Act can simply say whatever an employer wants them to. It's not the case that anything goes. The parade of horribles suggested by the appellee will not come to pass because even restrictive covenants, whether it's non-competes that are not subject to the Act or employee non-solicits, such as the case here, if they are not subject to the Act, they are still subject to Massachusetts common law on restrictive covenants. That means the covenant needs to be reasonably limited in scope. It needs to be no broader than necessary to protect a legitimate business interest of the employer, and it must be consonant with the public interest. Now, as I mentioned earlier—
Is that the same thing that gets incorporated into Section 24L? I don't know how many different subsections this is, but I'm going to say small Roman 8. Or is there a difference in what the common law prohibits and that section, subsection?
So this, in the Act, the common law requirements are incorporated. That is correct. There are additional requirements that are subject to non-competes that are subject to the Act. What I'm saying is this employee non-solicit provision is outside the scope of the Act. It must still comply with the concept that it be consonant with the public policy and no greater than necessary.
And is that something that would be, were we to agree with you on the issue that's been presented here, is the question of public policy still going to be a live issue on remand?
Absolutely.
Okay.
Excuse me, on remand. I thought you meant with respect to covenants generally. The trial court, in his order, actually determined that the employee non-solicit here did support a legitimate business interest. I can't recall specifically whether he discussed public policy, but he did determine that the covenant was subject to the Act, and that is what we believe should be overturned in this case.
So I guess the question I have is, I take it that the issue of whether the forfeiture provision is contrary to public policy or otherwise doesn't meet our common law test, that has not been litigated, and that would be a live issue later on in the litigation.
The issue of whether the forfeiture provision is contrary to public policy, there were multiple things briefed below, and one of the issues was whether the forfeiture was appropriate. Ultimately, the judge below did not decide that issue because he determined that he could resolve the issue by finding the covenant within the scope of the Act. So I do believe that that might come up when it is remanded, if it is remanded back to the trial court.
Just to right-size the case, what is the issue before us?
Well, there are a couple of issues, I believe. The main issue is an employee non-solicitation provision that is coupled with a forfeiture subject to the requirements of the Massachusetts Non-Competition Agreement Act? We submit that it is not, and there are a number of reasons for this.
Okay, so that's one issue. What's the other issue?
The other issue is even if you were to find that an employee non-solicit provision coupled with a forfeiture is subject to the Act, does that change if that employee non-solicitation provision is part of a transition agreement or a separation agreement, which is another exception to the scope of the Act here?
So long as you give them 7 days?
Yes.
Okay.
And then finally, the question is, even if, notwithstanding the fact that this was part of a separation agreement where the appellee was given time to revoke and did not do so, would the covenant nonetheless comply with the act. Now, again, we don't believe the covenant is required to comply with the act, but we find that if you were to
The covenant meaning the original covenant pre-act,
the employee non-solicitation provision,
prior to the enactment of the act. Is that what that is?
or even after. I mean, the employee non-solicitation provision in this case was initially entered into in 2017 before the act was implemented. Later, the appellee affirmed that covenant, the employee non-solicit, in her separation agreement, and that separation agreement was signed after the act's October 1st, 2018 implementation date.
And therefore,
I mean, we don't think it's relevant because, again, we think employee non-solicits are not subject to the act.
right, but that's issue 1.
Right.
Okay, so I'm on issue 3. I'm just trying to figure out what the issues are.
Okay.
Issue 1 is our forfeiture for for violation of a non-solicitation clause under the act. If we answer no, end of case?
Well, if you answer no, then the decision below gets overturned and we go back to the
Well,
Superior
end of
Court.
our case,
Yes,
on appeal.
yes, correct.
Okay. And then there's a second issue, but then the third issue was what?
The third issue is if notwithstanding the 2 exceptions to the act that we believe the non-solicit falls under,
If we nonetheless think the act applies,
correct, does this employee non-solicit provision still comply with the act's requirements?
So it's
the three
an
issues-
alternative argument, which is.
Correct.
they're all alternatives, right?
Yeah,
So
we comply.
So if we decide that you're correct on the first issue, that the plain language of removing non-solicitation is different, what's left in the case? Sorry, what happens? So we decide in your favor on the first issue. What happens, what's left in the case to decide? I'm confused a little bit. Forget about issues 2 and 3.
Sure.
You say you win on issue 1, we don't need to go to 2 and 3. I'm just trying to understand what's left in the case after that.
So when the case goes back to the Superior Court, we head to trial and we go in front of a jury to determine whether they believe that the appellee violated her employee non-solicitation provision, which
Right.
we think she did.
Right, I got you, okay.
So the concern here,
Just another question.
Of course.
We have this unusual sort of walking, talking guide through the legislative history and the drafting process. I've never seen anything quite like that before. How do we, and the trial judge did not have the benefit of that, is that right?
I believe you are referring largely to the amicus brief.
Yeah,
of-
the back amicus,
Yes.
the amicus brief.
You are correct that the trial judge did not have that.
Right, so he doesn't have that. And again, it's not like this is a legislator describing what a legislator did. He's sort of the draft person for the legislature. I'm trying to figure out how we treat this. Because it's incredibly informative, but it's a little different than anything I've seen before.
I agree, Your Honor. I agree that it is very informative, but I don't think you need, even though I found it very useful, I don't think you need that amicus brief to find in FMI's favor.
That I understand that.
So,
But it helps clarify a lot of the things that the trial judge didn't. Trial judge intuited various things, and this explains, well, okay, these 2 cases were out there, and this issue about, forfeiture, forfeiture based on non-competition versus forfeiture in general, all of that. But I'm just trying to figure out what we do with all of that.
well, I don't think it's necessary to rely on that because I think the statute, the text is very clear. The definition of a non-competition agreement in the statute says that it includes forfeiture for competition clauses, but it expressly and explicitly excludes employee non-solicitation provisions. And in fact, everyone in this case agrees with that. The appellee does not deny that. The question is whether the forfeiture for competition provision changes that. And we believe that it does not. Forfeiture for competition clauses are definitionally a subset of non-competition agreements. The statute says that non-competition agreements include forfeiture for competition clauses. But again, as I mentioned, employee non-solicits are excluded from the definition of non-competes. So it was not necessary for the legislature to say that a forfeiture for competition clause does not include a non-solicitation provision, because again, A forfeiture for competition clause is already a subset. It's just within the broader scope of non-competes. And non-competes, definitionally by the statute, exclude employee non-solicitation provisions.
Excuse me, can I just interrupt on that distinction, which is obviously so critical here? It seems a little interesting that the employee here is literally an HR professional. So
Right.
practicing her profession, which we think of the difference between is like a non-competition agreement, precludes you from practicing your profession. And so her profession actually involves hiring people. So should we think about it at all differently? I noticed there was one place in your brief where you said it would be, in the reply, I think, it would have been permissible for her company to hire your employees. It's just that she would have to not participate. She would have to not do her job.
Well, I disagree that was her job, or at least the primary function of her job. And interestingly, in the record, some of the solicitation that we believe violated her agreement occurred before she even started her first day at the new employer. So it wasn't that this was all in the context of her job. You know, as the chief people person or the chief HR executive, not only was she familiar with what these agreements meant and she voluntarily entered into the transition agreement, but more importantly, her job was much more than simply recruiting people.
Well, and also she could recruit from anybody else other than FMI. I mean,
Correct.
This provision really is just about not poaching FMI's employees to go to your new employer or anywhere else. It's, you know, the rest of the world is available.
That's correct. And in addition, as I mentioned, obviously they had an HR function at the new employer. They had an HR function that was someone solicited her. It didn't have to be the appellee who was involved in these third parties' hire by the new employer.
But I had the same, I'm just trying to understand when I read the language of the non-solicitation, she said she would not directly or indirectly solicit, entice, blankly blank, or persuade any other employee or facilitate the hire of any person who is employed or engaged by FMI. So she has to stay completely out of FMI hiring, right?
Correct.
Even though she's the
For
director.
1 year, though, is it?
1 year. And this was in exchange for approximately $1.5 million in separation
Well, I
benefits.
get it, and I get your point that she went out and actively pulled people right out of there, as opposed to like somebody from FMI applied and went through the personnel process at the new place. But is Justice Wendland's understanding how it works in your view? Because I had the same question Justice Stewart had, which is, okay, she's at the head of HR in this specialized industry. So she's now has to stay completely away from FMI. Is Ginkgo and FMI, are they both Boston-based biotech companies? Is that, I'm just trying to understand the logistics of this.
I don't recall whether Ginkgo is, FMI is.
I know where FMI is, I'd walk by
yeah.
it, but the other place, is it Boston-based too?
I think it might be, but I'm not sure about that. But again, she agreed it was just for 1 year. And again, it was just limited to the employees at FMI. And moreover, Your Honor, the question of whether that is a permissible and reasonable covenant, that is something that can be handled and should be handled by the trial court judge. The issue here is whether it is subject to the act.
You know, that was one of the questions I still had. Okay, so we have a statute that says non-solicits are not non-competes under this act. But does that statute preserve the common law of does it expressly say nothing here impacts the common law of non-solicitation? Is there something in that? Because normally the statutes displace common law rights, or often they do.
So I am not aware of a clause in the statute that specifically says, as for any covenant that's not governed by this statute, the common law continues to be uninterrupted. But certainly I believe that is the effect. This statute was only intended to regulate and only does regulate certain specific non-competes. Not even all non-competes, there are other exceptions as well. It's only certain non-competes where there's nothing in the statute that says, oh, and by the way, the common law for the rest of the covenants that are not subject to this act, you know, that's not going to get extinguished by this statute.
And the default rule is that the legislature needs to expressly abrogate the common law when it wants to do so. So the silence suggests that the common law persists.
Correct, Your Honor. I just wanted to mention that I think the fundamental problem with the Superior Court's decision is that it really elevates the remedy over the conduct being disincentivized. So again, none of the litigants in this case dispute that employee non-solicits are not subject to the Act. But what the trial court judge did was essentially say, when you couple that with a different remedy, that's now subject to the Act.
Right.
We disagree with
The
that.
trial judge doesn't have the benefit of this, again, walking, talking guide, which says we were concerned about forfeiture agreements, but a forfeiture without a non-compete is enforceable, but a forfeiture with a non-compete isn't. And that's what this was about. But again, none of that's presented to the trial judge, right? Yeah.
Correct, but again, as I said earlier, I don't believe you need that walking, talking guide. I think the statute is very clear that forfeiture for competition clauses are a subset of non-competition clauses, and non-competition clauses under the statute do not include employee non-solicits. I recognize that I'm over time, so we rest on our briefs. Thank you very much.
Very good. Thank you.
Morning, Your Honors. Jeffrey Rosen with Lauren Bressman for Ms. Miele. May it please the court. The statute is very clear that covenants not to solicit are not included. Ms. Miele is challenging a different covenant. It is the covenant to forfeit money, which brings her within a different part of the statute. The words of the statute say, in the first two exception, covenant not to solicit is excluded. The covenant that is the problem here.
Doesn't it say a covenant not to solicit is not a covenant not to compete? It expressly excludes it from that.
It's not a non-competition agreement, Your Honor. And a non-competition agreement is a forfeiture for competition agreement. Now, when FMI put together its 2020 agreement, it said if you violate the non-compete, the non-solicit, the confidentiality, anything, a non-disparagement in our new agreement, you will forfeit. Cheney, Pettingell, Kroger,
But they're not
Danahy?
saying they can enforce, they're saying we want the money back because she violated the covenant not to solicit.
It's a different covenant, Your Honor. We would have wanted the money back had she gone to a competitor. And to answer Your Honor's question, Ginkgo's
But
in
that's
Cambridge.
not the I mean, if they had tried to do that, that maybe would have been covered by the Act and maybe prohibited if it wasn't reasonable. That doesn't eliminate the fact that your client entered into a forfeiture for solicitation clause,
Your Honor, she
and
entered,
that's what's being enforced here.
that's what's choosing to be enforced.
Right, exactly.
The entire
And
agreement
so what-
had to comply with the law, Your Honor.
You're saying that because one part of the agreement was void, that the whole agreement is void?
I'm saying it's regulated. The statute
Because one part of
regulates.
the statute, one part of the agreement was regulated under the new statute, the whole thing comes within the
Correct,
new
Your Honor.
statute, even things that the statute says are not covered by the statute?
Your Honor, I disagree that it's not covered because
No,
if
no,
you
that's,
look at-
that's my question, is like, what, I don't understand that, but go ahead.
That's correct, Your Honor.
No, but yeah, can you explain it?
Yes, so the entire agreement from 2020 fell within the Act because there is a forfeiture for competition clause in it. We argue in every way. But it's undisputed that there was a forfeiture for competition had Ginkgo been a competitor and had FMI tried to stop Miele from working for a competitor. FMI is choosing to try to stop her from soliciting. The solicitation covenant is excluded from the definition of non-compete, but there's a separate definition if you're looking to get back money for engaging in competitive activities. And one of the key parts of that definition, Your Honor, is the manner in which you seek enforcement. That's Kroger, that's Danahy, that's even Cheney and Pettingell. If you read the actual non-compete, non-solicit language in Cheney and Pettingill, this court's own precedent, it actually says.
But doesn't it say that forfeiture for non-compete is not allowed, but a forfeiture in general? If you fire your associate and you tell her, if we fire, your payment is forfeited, that's okay. It's if you fire her and say she can't go work for Safar Shaw, that's not okay. Isn't that what the conditions that the statute's talking about are?
Yes, Your Honor, and in this Pierce decision, which was 2008, it's the triggered by competing. How do you compete? Triggered by competing. The language in Cheney that the legislature is presumed to understand, the language in Pettingill that the legislature is presumed to understand, says, in Cheney, if this employee joins a competitor or engages in activities which are harmful to the corporation. That's the Cheney language that built this statute.
Can
in
I ask one
Pettingill,
backup question? But you were drawing a distinction about if they have a non-competition agreement that's broader than non-solicitation. Did you argue that to the trial judge? Because that's not what the motion judge's decision talks about, that if it's got multiple provisions and they're only enforcing one provision, they still lose.
we argued that the whole thing was void, Your Honor, but
I just want to make sure, did you argue the point you're just raising now, which
we
is?
think we did, Your Honor.
Okay.
We think we did. We argued the whole thing was void, but actually looking back, what we needed to say was that the whole thing was regulated.
Well, how do you square that argument with Part D of the statute that says a court may in its discretion reform or otherwise revise a non-competition agreement so as to render it valid and enforceable to the extent necessary to protect the applicable legitimate business interests? That sort of sounds like if there's a non-solicit part that's okay, they can enforce that.
Correct, Your Honor, and hearkening back to your point, here, Miele is not at a competitor. She's not taking trade secrets. She's not soliciting customers of FMI and taking their secret formulas for their medical research. She is at a company, and I think we are taking a leap of logic in the facts to think that she was out there trying to pluck people from her old company to join her.
But that's a factual question. I mean, assuming the facts are that she poached people from FMI, just as sort of a basic assumption for the purposes of this appeal, I think. The question is, does the forfeiture for solicitation clause fall within the act?
And Your Honor, the reason why it does is because there's language in that definition that
Which-
says the manner of enforcement. And that's the Kroger
Which
case.
definition?
Sorry, Your Honor, forfeiture for competition agreement. It says the manner of enforcement. This court's decision in Cummings Property, right in 2007, right before the Pierce case in 2008, looked at what was the manner of enforcement here. What's going on in Cheney and in Pettingill? Those are cases, how are we enforcing this restriction on a
But
competitive activity?
Isn't the manner of enforcement here that they say she was soliciting our employees, therefore we are triggering the forfeiture provision? That's the manner of enforcement. They're not saying we're triggering this because she went to be the director of personnel at a biotech company up the street.
But if the manner of enforcement is because she's engaging in competitive activities, which those are, then it is
That's a whole
regulated.
separate question, whether those are. That's the first thing.
That is, but that's regulated by the law. It's regulated. You need to, 10 days before signing, tell you that an attorney needs to sign it. It's just regulated. And so this agreement here was. Now, Your Honor, in both the Kroger case, which is from the appeals court, this court's decision in Cheney, we look at what are we looking to do with the manner of enforcement? Are we looking to claim earned compensation, past compensation paid for past services? That's both Pettingill and Cheney, and it's Kroger. So here, Miele, one of the things that's going on here is that she had vested stock options that were accelerated during the transition period. That's earned compensation. That's roughly 90% of what FMI is trying to get back.
There's no question that there is a financial hit to your client. I mean, I'm confused as to why you're focusing on the manner of enforcement. Let's just assume that there's a financial hit, whether it's options or whatever. The question really is whether non-solicitation or forfeiture for solicitation, or I should say, that solicitation is a competitive activity within the definition of the forfeiture for competition clauses.
Right, Your Honor, because in the manner of enforcement, this court's opinion in Coolidge, which is cited by Cheney, this court's opinion in Cheney itself and in Pettingill is such that if you're trying to get something out of your contract that's not reasonable, and that's what the Cummings property case was, if you're trying to get something out of your restrictive covenant that's not reasonable, the courts will step in and say that doesn't work. And that's that manner of enforcement concept in the definition of
What's your
forfeiture
best case for
competition.
the proposition that the legislature, when using the words competitive activities, meant to include forfeiture for solicitation?
Two cases, Your Honor, both from this court. One is Cheney, where on
Cheney, as I understand it, was a forfeiture for competition.
and it actually, the clause that's being enforced, or engages in activities which are harmful to the corporation. And in Pettingill, Your Honor, this court's decision, it says, withdraws from the firm and engages in any activities which are in competition with the then current activities of the firm, he shall forfeit. Those are the decisions that formed the basis for this definition that the legislature specifically put into the law. And once again, we don't say that the covenant not to solicit isn't addressed here. It's the other covenant that's addressed here, and its manner of enforcement that's addressed.
I have a question as to the relationship between, well, I'll just say with respect to a couple of the provisions in the transition agreement and what effect, if any, they may have on anything. Subsection H of paragraph 10, other terms, talks about the entire agreement. It's the integration clause, essentially. It says it supersedes any and all prior discussions, oral and written negotiations, understandings, et cetera, et cetera, et cetera, et cetera, includes, and it also specifically identifies these previous agreements. Are we not supposed to take that at face value? And if so, what effect does that have? I may be wrong on this, but is the non-solicitation clause only in one of the earlier agreements, or is it also included somewhere in the transition agreement?
Your Honor, it is only in the 2017 agreement. The transition agreement references the 2017 agreement and, in our view, and the trial judge below agreed, added terms to it.
So how do you then reconcile that position with subsection H?
In subsection H, I'm sorry, Your Honor, again, from the actual agreement or from the?
From the transition agreement, which says that it supersedes, and this is the entire agreement.
It incorporates and reaffirms that agreement. The transition agreement in another section incorporates and reaffirms that agreement.
Right, and
then
it
adds
also referenced those. Okay, so in your view, the non-solicitation provision survives despite this subsection H?
It survives and it gets added to. And the added to is this other covenant that, in our view, brings it within the definition of a forfeiture.
Okay, so now, then look at subsection C, which is severability. I mean, there's also modification in there, but I'm really only interested in the severability portion of it. So this is a pretty, routine severability provision that says if one provision is unlawful or unenforceable, the others still survive. Given that, I have a hard time, to be frank, understanding your argument that the whole agreement has to be seen as a competition agreement and therefore a forfeiture for competition agreement and therefore a problem under the Act, as opposed to looking to the specific provision that your client is alleged to have violated, which is the non-solicitation provision. Because this looks like you agreed to severability. Can you please talk about that a little bit?
Thank you, Your Honor. That's what I would look to this court's opinion in Cummings property that's in our brief on page 22. If there are breaches of an agreement, and some of them are just simply not material, then the penalty that's at issue is scrutinized in light of that. And that's exactly what this court says in Cummings properties. So to Your Honor's question, if the non-solicit is all you want to enforce, but it only has to do with 2 or 3 people reaching out to you, you responding to them, one of them coming to your company, another one going to a related company, a third one not even coming to your company at all, Cummings property, and we think Pierce, Cheney, and Pettingill all say that's scrutinized here, and it's not just the alternative question below after this court's ruling. It's this court's ruling.
I mean, why isn't that why isn't what you're identifying there the question of whether there was a breach as opposed to whether this particular non-solicitation provision falls within the statute?
Because, Your Honor, under that logic that I just presented, I would say that can't be severed. That is an immaterial breach. It is unreasonable. It's an unlawful restraint of trade. It's a forfeiture for a competitive activity that falls squarely within the definition in the law, and this court should.
You get there by coupling the non-solicitation provision with the forfeiture provision.
2 different covenants, Your Honor.
Sure, but what if you just looked at the non-solicitation covenant?
If you just looked at the non-solicitation covenant, Ms. Miele has said below, no issue, prove your consequential damages.
I think I understand your argument now.
Okay.